Hey everyone, it's Rob Ryder. It's Monday, January 21st, 2013. We're going to follow Bob in Massachusetts foreclosure case. And Massachusetts does it a little bit different. Go figure, everyone's a little bit different. Um, they have a particular statute code, whatever. A serviceman's, what do they call this thing here? Servicemen's Relief Act, is that what it is? Servicemen's Civil Relief Act, right? Okay. 50 U.S.C. App, subsection 501. Anyways, they've adopted this in Massachusetts. So before you can do a foreclosure, you have to go and see if the guy's in the military, because if he's in the military, you can't foreclose on him while he's on active duty, apparently. So I think they do this first, right? So this is the first thing they did. And they took it to a place called the land court. That's what Massachusetts has. Complaint to determine military status. So the plaintiff, they're saying GMAC Mortgage LLC is the plaintiff, right? Has an interest in a mortgage with statutory power of sale. So they want to use the statutory power of sale that's on the deed of trust, right? There's a power of sale clause in there. By Robert to Mears as nominee for Sherwood Mortgage Group, its successor and assigns, yada yada yada. Okay, standard stuff. The book and page where the mortgage, where the deed of trust is located at. No defendants are in the military. Plaintiff alleges an information and belief that the defendants are only persons holding the equitable redemption of property covered by mortgage. All right, so they're saying that Bob has equity of redemption of the property covered by the mortgage described in paragraph 1. Excellent. He's got equity. He has the equitable title. The holder of the mortgage seeks to proceed with the foreclosure for said mortgage described in the paragraph. Breach of conditions thereof, desire to comply with provisions of. So again, before they go and foreclose, they're supposed to come to this court and get a ruling if the people they're foreclosing on have anything to do with the military. You know, I'm not going to make any more on that than it is. It isn't that big a deal. It's just a step, right? Step 1. And they want to have an order of notice to appear and answer this complaint. Are you in the military or not, basically? For judgment declaring the defendant is not entitled to the benefits of the Service Relief Act, Service Members Civil Relief Acts. So, again, it's just to determine, are you in the military? And if not, well, then you don't have this protection, and they can go ahead and foreclose on you. That's their idea. So, the next thing they put in, and we forgot to cover one very important thing. The whole reason we're doing all this. Okay, so this is the complaint, right? And GMAC Mortgage is the plaintiff. But who signed the complaint? The attorney did. Well, the attorney's not a party of interest. Only the plaintiff can sign the frickin' complaint. As far as that goes, he needs to put it under oath. Otherwise, I don't need to answer a false accuser. So they put this piece of paper in, and they're asking to have this order of notice, right? So, but here's their affidavit, right? This is the affidavit from the mortgagee. Pop this up a little bit. And then we get it all in there. The undersigned makes oath and says that it is, check 1, the mortgagee of the mortgage, which is subject to this. So they're not the mortgagee or one who holds under the mortgagee. They're not either of those. They're saying one who is authorized to act and on behalf of either the mortgagee or one holding under the mortgagee. Right? So they're saying that the mortgagee on this mortgagee affidavit, who's ever making this oath by GMC Mortgage LLC as servicer. So he doesn't say they're the mortgagor or mortgagee, they're the servicer, right? That they have authorized to act by and on behalf of either the mortgagee or one holding under the mortgagee. Then on this complaint, GMAC isn't the mortgagee. If they're foreclosing and they're not signing it either, they're having this attorney sign it. Houston, they got a problem. And the undersigned further makes oath and says that the undersigned or a prior holder of the mortgage has caused to be mailed the notices to defendants, mortgagors in compliance with Massachusetts General Law, Chapter 244. Right, so I'm going to have to read that and see what that says. Bob probably has. I don't know what it says. But so again, the plaintiff's GMAC is one who is authorized to act by and on behalf of either the mortgagee or one holding under the mortgagee. They're not the mortgagee and they're not the one holding under. This will be interesting. So these two pieces of paper, I wanted to point this out too. Where was the date on this? When did they put the thing in? I think it's like September they put this in. And, you know, they don't even tell you that you're being foreclosed on until they put this in September. Bob didn't know it until December. There was nothing sent. They wait until the hearing date is coming up, and then they send this stuff out maybe 30 days prior to give you very little time to prepare. Huh. And then this is the order of notice that they talked about. See, they're nice enough to write all this stuff for the judge ahead of time. All the judge is going to have to do is sign names. So what this is this is something that they're supposed to post in a newspaper for at least 1 week, and then get an affidavit of publishing and put it in the court file. Okay, so to all persons entitled to behalf of Service Members Relief Act. Okay, and it's supposed to read like this is right here. So we'll get back to this later. We'll save that one for later. But these are just the pieces of paper that were put in with the court case. Instructions for order of notice. The plaintiff is hereby ordered to serve the within notice by making a copy or copies of motion and publishing the same once in the following newspaper of your choice. And they said the newspaper they would at least 21 days before the return date. Making a copy of the notice of mailing by certified registered mail. All right, so it had to come certified or registered not less than 14 days before the return date. So these are the three things they had to do: recording, registering the enclosed attested copy of the said notice prior to the return day at the Register of Deeds. Three things they have to do. Okay, and what they're saying is that whatever this says here on this order of notice is supposed to be published, newspaper of choice, once, and they put it in the Norwood Bulletin. Okay. And then this would be the copy of Lang court use only under the provisions of boom boom boom. Heard thereupon, basically saying that Bob isn't part of the military, right? So all these pieces of paper are put in by the attorney ahead of time, and that's why when they get to these hearings, it's just stamp, 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 because, you know, we're not answering the right things, and They're just going to keep giving them paper. Okay, and then return order. Return on order of notice. I hereby on oath state that I have published a copy of this, so that this is what they're supposed to put in, and then I believe this is what goes into the well, it'd have to go back in the court file. Say that they had published this for 1 week in the newspaper. Okay, so that was the that's the plaintiff's first salvo. Let's see what Bob did. How did Bob answer them? Well, he put in an answer that said this. So again, he's answering a case that's already going on, so this doesn't cost any money, right? If you open a civil case, you have to pay for it, and that isn't all bad, because you could be in it, claim to be an indigent, ask them for the form. A lot of these forms they keep under the counter, and if you don't ask for them, you're not going to get it. Same with a civil action sheet, civil action cover sheet. So Bob's answer to them was responsive answer to complaint invoking equitable defenses, counterclaim by motion for summary judgment, and just remedy based on the preponderance of the evidence. Responsive answer to complaint. Plaintiff comes to equity with unclean hands. Plaintiff's complaint is not under oath. And he put an asterisk and put this in later, but we'll just go on. And I'm not bound to answer false accusers. I demand the plaintiff testify to the validity of their claim under oath or be found in contempt of court. I further believe the complaint to determine military status has nothing to do with me. Please put more definitive, detailed explanation as to what this act has to do with me under oath. In other words, I haven't got enough information, because we continue on that the plaintiff's complaint is far too vague for a reasonable man to determine what evidence is the basis of their complaint. And as owner of property in dispute, I lack knowledge or information sufficient to form belief as to the truth of the allegation. I demand to know by what authority the plaintiff filed this complaint, and their attested evidence entered into the record. Counterclaim for summary judgment and order for swift justice. So here's the defense. It's a written appearance. And maybe we should put written special appearance, because when you say special appearance, it means you're not consenting to the jurisdiction of the court. But nevertheless, it seemed to work. So we went right from the defense, right? So this is the answer to the complaint, this part here, 1 and 2. And now we're going into putting in for a counterclaim. Counterclaim for summary judgment and order for swift justice and just remedy based on maxims of equity and preponderance of self-authenticating foolproof evidence in the form of public record. We have public records that validate our claims, such as the fact that the plaintiff didn't sign the oath, right? That's in the court record. It's sitting right there. Well, that's not the plaintiff that signed it. That looks like somebody's attorney, and they can't sign the complaint. They're not a party of interest. In reality, the bank is represented by the bank president or CEO, CFO, whatever you want to call them, right? That's who represents the bank. So Bob slipped in here. Plaintiff of case never signed complaint or provided testimony under oath to the validity of his claim. See, you can handwrite this stuff as bad as Bob's handwriting, they'll still take it. Therefore, plaintiff has no standing. And I did a talk show on which Bob was explaining all this, what happened and so forth. And big thing that he was told is you need to bring up standing. So we wanted to put that in there. And then it went on. It was a 2-pager. order for declaratory judgment, summary judgment, swift justice, and just remedy. We're going to throw the kitchen sink at them, right? Because we really don't know what we're doing. We're not learned in the law. We're just trying to protect ourselves. This counterclaim coming to be heard on owner Bob's estate, motion for summary judgment. Heard on owner of, so Bob's the owner, right? If they ever ask you, who are you? Like they asked Roe, say, well, I'm the owner of, your all capital letter name, estate. And I'm motioning for summary judgment, swift justice, and just remedy against plaintiff's intent to use color law process and unclean hands to enforce an imperfect gift. And the court, finding no material issue of fact that has been raised, it is hereby ordered that summary judgment in favor of owner is granted, entitled deed, securities, their conversion and gain, as well as rents collected on owner or for owner be placed in the hands of the owner of, boom, who is Robert Shalmo. Now, I don't know if Bob put it in here now. I have to go back and look. You know, we all know our given name is the only one that matters. God-given name. It was a gift from the Creator. He knew your name before your family, right? It's one of your God-given rights. And then they tag this surname on, but they have a thing called the full real name, and that's your surname, last name, whatever you want to call it, first, comma, space, first and second. Full real name. And we may want to be putting that, you know, by operational law, our full real name is. But, well, you know, we're working on it. Further, it is ordered that a special master, expert in real estate law, shall be appointed to owner, whose full real name is, there goes Bob, of that estate. He's the owner. This is his full real name, and he's the owner of this estate. To ensure said owner receives full and complete relief in equity by way of natural justice, to establish for the record the owner's superior rights, title, and interest to all his property and interest to all his property, and protection of his God-given rights. And so that whole last paragraph is, you know, if you ever get a chance to use it, has to go claim all your estate, everything under your all capital letter name. Right now we're just going for one account. That, you know, the property, the house, is just one account of your master account, which is under your all capital letter name, which is the name of an estate. It's your business. It's your national bank, right? It's a good thing. It's yours. Claim it. It's your frickin' property. I am the owner of myself, Robert Allen Ritlewski. It's my property. If you want to put a claim against it, you better put it under oath. All right, so that was his answer. And when did we do this anyways? This was, you know, not that long ago. 27th day of December. What's today? We say 21st. 21st day, right? So 3 weeks. Barely. All right, so Bob put his answer in, and this would go as a motion, and now the plaintiff is going to have to answer his answer, because he had questions he wants answered. And they didn't do it. So this got filed into court, and within a few days a judge looked at it and decided, yeah, must be okay, because he set a hearing date for the 25th of January. You know, this coming Friday. So that's where we stood until the 17th, when Bob called down to see if if there had been an answer put in yet by the plaintiff, and what was going on with the case. And the guy's looking at the screen, and he said, and to see if they had put in the affidavit to say that they had published this listing, the publication. And so Bob's talking to the clerk on the phone, and he's looking at the file. Says, anything new in my file since this happened? Gave the file number, yada yada. Well, since you put in your order for declaratory judgment, summary judgment, and just remedy, the only thing in there since then is a judge's order put in the 17th. And so Mom's actually calling the 18th. This had just happened the night before. And a copy, and so the guy said the copy's been mailed to you. Well, they didn't have the file back in the clerk's office yet. It was still in the judge's office, so they couldn't go get it and read it to him, or they'd have been happy to. But it wasn't in their office yet. So, all right. So that was what Bob did. Went too far. And then this is what the judge did. So this was the order the judge put in. Norfolk SS. Always interesting. We got to really pay attention to what these names of these courts are. In another video here soon, I'll show in rows. You know, they slip in the name of the city sometimes in the county. Sometimes the city isn't there. Sometimes it's called a district. Strange. Multifaceted court, to say the least. But this is what the judge had to say. In this case brought by the plaintiff, GMAC Mortgage, to determine whether defendant is entitled to protections of the Act implemented in the Commonwealth. All right, Mr. Schummel does not claim to be entitled to the benefits of the Act. Rather, he contests this action on a variety of unrelated grounds, some of which may relate to the plaintiff's standing. Yeah, like he doesn't have any standing. Absolutely. So the Supreme Judicial Court has now decided in, you're going to want to look this up, this case. I think I found it by just putting in the case number. Case number, whatever. Outlining the parameters of a standing challenge. So this is a case in Massachusetts. The party bringing a service member's case must show that it is either the mortgagee or acting on behalf of the mortgagee, right? And again, I can never remember which ones to keep open. Let's look at that affidavit they put in. Mortgagee's affidavit. All right. So this is what they're talking about. Either the mortgagee or acting on behalf of the mortgagee. All right, so those two are in there. But it says, with the mortgagee defined as the person or entity then holding the mortgage, and also either holding the mortgage note. Now please, it doesn't say promissory note, it says mortgage note. Mortgage note has its own definition. So holding the mortgage and the mortgage note, or acting on behalf of the note holder, that showing may be made by affidavit with nothing else more required. The defendants may challenge the sufficiency of that affidavit only. Okay, so anybody in Massachusetts, you can just challenge the sufficiency of the affidavit only. If he or she is entitled to, go down and look at this thing. Not the order of notice. This one. Right? So our sufficiency is to these people as the servicer, right, have any standing to bring a charge. A showing may be had by affidavit with nothing else required. That should be all you have to put in, is that right there. The defendant may challenge the sufficiency of that affidavit only if he or she is entitled to the Sorry. Nope. Judge's order. Benefits of the Servicemen's Act. any submission or filings by anyone not so entitled may not be accepted by the court. Because the serviceman's proceeding is not part of the foreclosure process, in any separate action challenging a foreclosure or a mortgagee's right to foreclose, the fact that the purported mortgagee was determined to have standing to maintain the service member's proceeding does not in itself in any way establish purported mortgagee status as such in that separate action. Any submission or filings by anyone not entitled may not be accepted by the court. See, they were talking about the Service Members Act, then he slips this sentence in all by itself. Any submission or filings by anyone not so entitled may not be accepted by the court. And, as we're going to see, he's not accepting this affidavit, even though he said Bob can't challenge it. He's not accepting it. Because the defendant's other arguments are outside the scope of these proceedings. As held in MAT service member proceedings where non-service member defendants may not appear and be heard, are not determinative of any issue beyond the extent of such defendants' rights under this. This hearing is for one thing only. It's limited jurisdiction. And their limited jurisdiction is, are you a service member or not? So when Bob had put this in on the 27th of December, within a few days his hearing date had been set up for the 25th. Well, come the 17th, which is the shortest possible time that the bank and the attorney could have answered, the judge put this order out. And he's saying the hearing scheduled for the 25th is unnecessary in light of the MAT decision and will be removed from the docket. GMAC Mortgage is directed to submit a new affidavit showing that it is either the mortgagee or acting on behalf of the mortgagee, as these terms are defined above. In other words, they have the mortgage and the mortgage note, not the promissory note. The promissory note that you have in your file was never a promissory note. It has always, from the day it was created, been a security. It doesn't matter what the title is. What matters is what it does. And since a security is any note that has a maturity greater than 9 months, then it was a security because it's a 20, 30-year note. They're talking about a specific kind of note called a mortgage note. So if it's not received in a reasonable time, this case shall be dismissed without prejudice. Okay. So they're supposed to do this prior to a foreclosure process. And the judge has made it quite clear that this case here is nothing to do with the foreclosure. All that's supposed to happen is the mortgagee, the one who has has the mortgage note and the mortgage, is making sure that you're not in the military so that they're not violating some state law. Okay? So, in that case it referenced, there were a number of interesting things. The Act adopts the principles of agency for mortgagors, and there is nothing to suggest the same principle not apply to mortgagees. Right? Same principles. It adopts the principles of agency for mortgagors. In other words, you have standing to be there. Well, they're saying the same thing for the mortgagee. Does the mortgagee have standing to be there? The judge may, but need not, consider an affidavit filed by a plaintiff pursuant to the rules as sufficient to meet the burden. He may, but need not. And so he's not accepting this one they put in. He's telling them to submit a new affidavit showing that it is either the mortgagee. So he's saying by this order they're not the mortgagee by what they checked, by the fact that it says GMAC as servicer, not mortgagee. Right? And they took an oath. So either this is a self-confession, undersigned makes oath that they are one of these. One who is authorized to act on behalf of either the mortgagee or one holding under the mortgagee. So they must be saying that they're one holding under the mortgagee, because apparently they're not able to act on behalf. Because standing to bring service member proceedings is limited to plaintiffs who satisfactorily establish that they are mortgagees or agents thereof. And again, the judge wasn't happy with her answer. Temporary suspension of judicial administrative proceedings and transactions that may adversely affect civil rights of service members during their military service. Okay, that's what the act was for. Seeking to assure compliance with the prior to commencing foreclosure, so prior to commencing foreclosure proceedings, so there shouldn't really be a foreclosure going on right now, could bring an action in equity to obtain an appropriate court order. So they're going to the land court in equity to get this court order to allow them to foreclose. And as 3 different attorneys have said in the last week, it's all equity. Don't argue with it. Use it to your advantage. In proceedings under this section, no person who is not a record owner of the equity of redemption, and they said that Bob was the record owner of the equity of redemption, that we should find out if we're the record owner in the mortgage property, and who is not entitled to the benefit of, and so he's not entitled to the benefit, shall be entitled to appear or be heard in such proceeding except on behalf of the person so entitled, or unless an affidavit by the claimant. Okay, so it's not saying that you can't be seen there. If you put in an affidavit as the claimant, you can be seen there. And that's what Bob did. He put it, when he signed under penalties of perjury on his complaint. On his answer, they saw the paper. Service member proceeding occurs independently of actual foreclosure itself. So this again this isn't even the foreclosure. The land court service member action does not mark the commencement of foreclosure proceedings. So there's no foreclosure going on with this. It has to be happening somewhere else. And so we're going to figure out what that means. That's why the judge couldn't give any more relief than he did. It's not where the foreclosure is happening. He's got very limited jurisdiction in this particular hearing as to determine one thing only: you in the military or not. And just more, how many times can I tell you, this is not the foreclosure. It's not the foreclosure. Anyways, you can go read this. These are all little excerpts from that little the case that the judge referenced. The plaintiff be powered authorized to make an entry into sell property covered by a mortgage as set forth in this complaint in accordance with powers contained in said mortgage. Right? That's what they're trying to get to be authorized, but the judge said, well, put on the right affidavit first. Therefore, the plaintiff must establish standing. Are you the plaintiff? Do you have the mortgage and the mortgage note? Not the promissory note, not that security, 30-year maturation. No, the mortgage note. To have standing in any capacity, a litigant must show that the challenge action has caused a litigant injury. Well, you can't do that when you're the servicer. You can't be the servicer because non-mortgagees are not by law in a position to foreclose on a mortgage. Beautiful. Only the mortgagee. And they didn't say they were the mortgagee. They said they were the frickin' servicer. And an attorney signed the complaint. Well, he's not the frickin' party of interest either. Right? Crazy stuff. All right, where's the one we're looking at? Oh, this here. Plaintiff claiming to be the holder of a mortgage or trust deed. Didn't say deed of trust, said trust deed. These are the land documents. Mortgage and a trust deed are the land documents, or security in the nature of a mortgage, and that would be the deed of trust they get you to sign. It's a security instrument. In the form of a mortgage, because it gives them a mortgage on the equity. You're giving them an equitable mortgage by giving them a deed of trust that only you've signed, that they haven't signed, and now it's a unilateral contract, and they have it in their drawer, and they're going to say it's a gift. You signed. Well, I didn't mean it to be just me signing. Where's the loan? Where is the mortgage note and the mortgage on the land? We conclude only mortgagees or those acting on behalf of mortgagees have standing to bring service member proceeding. Okay, and they're supposed to do this prior to the foreclosure, right? So the judge said, well, not yet. You haven't put in the right one. You haven't put in the right affidavit. However, under oath, they said that they're the servicer. And the judge is saying, well, that isn't the same as a mortgagee, so you're going to have to do it again. If you don't, he's going to dismiss the case. Without prejudice, mind you. But again, this isn't the foreclosure. We're going to go foreclosure hunting. Find out where it is. Or Bob's going to have to put in, like Roe did, and Bobby in Arizona, we'll just put in our own civil action and go get our property back. But, you know, this stopped the foreclosure. Took 21 days. Boom. Not going any farther until the plaintiff puts in the frickin' right paperwork. And they're not accepting this anymore. Okay. So, close some of these up. I get confused. What else do we have? Oh. Open this one up. This is interesting. So I asked Bob to go down and find that newspaper that had put his in there, the legal notice. And I'm not going to go show the other one again, but as you can see, right, whatever was on that piece of paper is supposed to be put in the newspaper, right? Word for word, what's on that document is supposed to go in here. Well, this talks about, now this isn't Bob, this is somebody else. Wells Fargo Bank as the trustee, right? So the bank is the trustee, and it's listing the asset-backed securities that go, right? This is the property they're talking about. That's your property. You own this frickin' OOMC 2005-HE6 as it applies to you. All right, and then they get into the stuff that was in the rest of the stuff is, you know, what was in the order. So what they put in the newspaper doesn't match the order. So if you've lost your property in Massachusetts, what they put in the newspaper doesn't match the order. That's a procedural error. And what I want to know is what this stuff is at the bottom. So this is all, you know, what it's supposed to be. But at the bottom, OOM 12 something, FC 01, DaCosta 01. You know, those are different file numbers that go to something else. That OOM 12, whatever, I don't know what that is, right? Is that part of this OOMC? And so this is this person's cut, DaCosta. This is the value of the personal property that they're trying to claim, because they're claiming the deed of trust that you gave to them that only you've signed and they haven't signed, so it's not a bilateral binding contract. It's a security instrument. It says it's a security instrument, and security instruments are used as security agreements, because when you read what you sign that you agree to the security instrument, well then where's the bank signature that they agree to it? It doesn't exist. So Bob's going to go down and find his, and we're going to see what the bottom of this stuff is right here. Right? Because they did put this in the newspaper. He did see something listed in the newspaper, but it was a couple weeks ago. He didn't have a copy of it. Okay. So, what else was there with Bob? Shoot. Massachusetts. Bob's case. Okay. So, let's look at civil action cover sheets real quick. Right, this is on the back side of the civil action cover sheet. That's the back. Where's the front? So if you were going to put a case into the trial court of Massachusetts Superior Court, department, and whatever county it's in, this is all proper case stuff. It's not upper lower. Excellent. You know, you're supposed to fill this out, and this goes on top of your pleading, petition. Call it what you will. It's an original complaint, so you got to check a box. Original complaint, some kind of, removals, district court appeal. Right? So if you wanted to appeal a district, let's say you had traffic tickets through the district court, right? You would check this box. Type of action to track. Okay, so just different types of actions. And we're not doing any tort claims, right? Don't put any money values down. We want to determine rights, title, and interest, and none of those have anything to do with money. It's not a contract claim. Kind of in a way it is, but it's because they didn't sign a contract. Alright, so this is the back side. And then they have all these different things that you can pick to put on the front. Let's select the best that describes your case. Foreclosure of mortgage, dispute, right? All different things that you can pick. Equitable remedies. We like to pick out of the equitable remedies. Declaratory judgments, minority stockholders, imposition of trust, conditions of indemnification, specific performance of a contract, which is one of the things we're trying to get. Is we want the purchase agreement, which is the warranty deed between the grantor and you, to be closed. That's why they call it a foreclosure. For is before closure. This statutory action happens, and if we allow it to be called a foreclosure instead of what it is, it's just a contract issue, right? Then you fall under the foreclosure stuff, the foreclosure statutes. And I don't have to. I'm going to say they didn't sign the contract and call it what it is. Okay, so these are just, this is what this sheet you would put on top of your petition, and you should go read everything that it says, like Superior Court rules. Shall set forth the fact sheet, attach additional sheets as necessary, a statement specifying in full and itemized detail the facts upon which the plaintiff then relies as constituting money damages. A copy of civil action sheet, cover sheet, including statement as to damages, shall be served on the defendant. Okay, so this just tells you what to do, right? Basically, you need to have this cover sheet and a list of facts. And the fact is, they didn't sign the contract. Okay, so that's what those are. And just real quick, here's the definition of a mortgage note. In the United States, a mortgage note, also known as a real estate lien note, is a promissory note associated with a specified mortgage loan. Okay, specific mortgage loan. They haven't shown you the loan. Anyways, go read mortgage note if you want to know more about that. This is what one's supposed to look like. right? This is a mortgage note. It's a little one-page form, right? Is your promissory note this short? Again, I just Googled mortgage note, found the short form thing, but this is from the Huron Title Company. So the long and short of it is, in 20 some days, the court has said that whoever put the initial paperwork in for the complaint and the affidavit aren't the parties of real interest. And I'll find a better way to do this. Where is that order? And GMAC is directed to submit a new affidavit showing that it is either the mortgagee or acting on behalf of the mortgagee. They haven't done that yet. As these terms are defined above, once the affidavit is received, judgment shall enter declaring that Bob is not entitled to benefits of the Service Member Act. If it is not received within a reasonable time, this case shall be dismissed without prejudice. This judge didn't waste any time. He put this order out the very first day he could after the mandatory time for answer could be given, my opinion. And he's saying, hey, you're right, they're not the mortgagee. I'm going to make them put in an affidavit. And, if they won't put it in, whatever this foreclosure case is, you have their self-confession that they're not the mortgagee. Okay, well, that's that one. I'm going to do a couple more on other cases that are going on, but kind of keep these short and to the point. So that's what's happening in Massachusetts, and we're staying tuned for more.